Remarried parents and stepkids, I want you to listen. What's the difference between a verbal promise and the legal reality when an estate plan changes? I'm Valerie Zammitti of Zammitti Law. We're an estate planning practice in New York and New Jersey. We provide peace of mind to families through our high client value services. If you are seeking assistance in either estate planning or probate administration, you can reach out to us for a free consultation at yourplanningattorney.com. And speaking of value, we're always here educating for free as well. So please ask your questions and share so together we can help some folks along the way. Now, let's put this in a reality perspective. If dad has promised you his 2 rental homes through his trust, but then he sells them because your stepmom convinces him to, he then says the money is still for you. Is that enough? I don't think so. So let's talk about it. And if you are someone who's ever been promised something to just turn around and find that they haven't followed through with that promise, this also is something you should listen to. Now, the treatment of assets of any individual after someone's passing is first controlled by various factors of law. For example, how that asset is owned can impact whom receives it. For instance, a joint bank account with another party will automatically become owned by the surviving party, regardless of their estate plan. A beneficiary designation on an account will go to that beneficiary, regardless of an estate plan. In addition, spouses do have some rights within state law to receive at least a minimum amount from their deceased spouse's estate, even if they have children from a prior relationship. So, if those controlling ownership rights do not apply, and the spousal one you can't really avoid, although I'm going to address in a minute, then the estate plan of the person holding those assets, right, and their specific wishes on who will receive it is imperative, right? They're written directives. And in this circumstance, there was a trust designating these properties. But if the properties themselves were specifically what we call bequest, there was a specific bequest to you as the daughter to receive those rental properties, but they no longer exist, then those provisions don't apply. It's as if it was never there. It's really best if you do address this with your dad, right? First, affirming his wishes and explaining your new knowledge that if he hasn't updated his trust since the sale of the properties, then his wishes are probably not going to actually come true later. They're not going to be followed through. That won't be the case because the properties don't exist. And if this is still his intention, that he'll need to update his estate plan. So what does that include? What should he do if that is his intention? First, he can either make a specific bequest of the particular account where the proceeds are to you, but even better, make a specific dollar or percentage amount or allocation to you as his beneficiary to cover that. This way, if the current account where those proceeds are, if it's only one account, if those are no longer there, if that account's no longer there, we're not stuck in the same position. Now, you should make sure that the distribution to you happens at your dad's passing rather than waiting until the potential later passing of your stepmom. Now, with a caveat, if dad wants those monies around and available for your stepmom should she need it, then it can still be there, but held in a trust that your stepmom will not be able to necessarily adjust or control, so that anything remaining does go to you. This is often what we need to do and think through when there are blended families. Alternatively, although not preferably, dad could name you as a direct beneficiary of those assets at the account level. And it's not preferential in my eyes because it doesn't offer you any protections after he's gone. And lastly, this is a little bit more sensitive in my eyes, but again, occurs pretty frequently, or at least we suggest it frequently with blended families, that if the parents are trying to protect their own children, right, and they don't have a need to give a significant portion of their estate to their new spouse, then it's best for those spouses to sign either a postnuptial agreement or what we call waiver of elective share that essentially says, hey, we're not going to try to collect more from my now deceased spouse's estate than what we've allocated to one another. So that it's essentially protecting the respective children of those spouses, right, from the prior relationship. Good intentions do not automatically become good outcomes, right? Not without the written spelling out of what those wishes are and documentation to reflect that. So the sooner you have the conversation, of course, the better. Just make sure he's in a good mood. These are sensitive discussions, and you want to go into it when you're both sort of, clear-headed and open to chatting. So his current wishes can be properly reflected in his plan, and you know that they'll be followed through with. Again, I'm Valerie Zammitti of Zammitti Law, estate planning attorney in New York and New Jersey, and we provide peace of mind to families through our extremely high client value services. If you do need help in estate planning or probate administration, you can reach us for a free consultation at yourplanningattorney.com. Hope you've learned something new here today. Don't forget, share, and take care.